Hi guys! So we are back for the YSL reunion, Lovapalooza. It's going to be part 3. This has just been something that we kicked off this weekend, and it's been an amazing time. It's been an amazing time. Sorry I started late, but I was about to cue us up to a part that Factual Lie had recommended. I think you guys will remember it once we get into it. It is the Truth of the Matter Asserted Day. And I had it all queued up, and then I realized that right in the beginning of the stream, when Law and Crime starts this day off, it cuts in mid-sentence, and Love is getting in trouble again. So we're going to watch a little bit of the beginning, then jump forward to really one of the times in the trial where Whitaker loses it the most with Adrian Love. As a quick refresher on the issue of the truth of the matter asserted, when we're dealing with something that is hearsay, and we're trying to find an exception to hearsay, we have to have a valid reason for wanting to bring a out-of-court statement in for a reason other than the truth of the matter asserted within that statement. So, for example, if I wanted to say, should I use that biscuit example? Let's say Miss Chocolate here and Factual Lie are hanging out, and Fatima gets wind, she hears Factual Lie say Miss Chocolate was eating all the biscuits in the break room. Well, we can't use Factual Lie statement. The jury is not supposed to consider Factual Lie statement that Miss Chocolate ate the biscuits as truth that Miss Chocolate actually ate the biscuits. But we might be able to introduce that being said because maybe Fatima took a specific set of actions because that's what she heard, and in that moment she said, well, let me go and look in this room and investigate. So there's an exception right there. And while we have one of our favorites, Michael Sprinkel, on the stand, Love tried over and over during the lunch break before Sprinkel's back on the stand to consider cross-examination. She was arguing through the lunch break of this day to get Whitaker to reconsider statements that she'd already excluded because there was no way around the hearsay rule. Love couldn't come up with an exception. So she gets through. She does win reconsideration of a few of them if she can lay the foundation or whatever. But ultimately, she's not really proving her argument. She's not offering exceptions to Whitaker's satisfaction. Somehow, we still have a mess. So we're going to look at this little bit in the beginning where she's yelled at for other matters. If you guys want to watch the evidentiary arguments, they are a bit long and grueling. It's like a 30-minute lunch break of Love going line by line, trying to get Whitaker to let things in again. If you guys want to watch that, we can. But other than that, we'll jump right to the part where Love starts doing redirect with Michael Sprinkel, and we end up having to stop because she puts up an exhibit with some information that she wasn't supposed to introduce, and she cannot justify her reason for doing so. So you guys vote. Good to see everybody. We've also got a nice, not the biscuits example. I had to do it. Not to give away too much, but we're going to have a good order of events as we go through this. We've got 2 follow-ups that will follow this specific incident that are all interrelated that I think you guys will love to look back at. And Nem says, I know who ate the biscuit, but I'm pleading the 5th. There you go. Hold on now. Don't have Prosecutor Love have an ex parte meeting to get you some immunity going. So let's look at, and I'm telling you, right in the beginning, let me move my picture. This would have been, we used to kick these streams off at like 8:30 a.m. Eastern. We used to wait for court to get live. And this day, the action started right away, straight out the gate.
She is on her way. There was, I think, some problems with traffic.
Okay, so, Ms. Hilton, Sunday, September 29th, 1:39 p.m. Good afternoon. I hope all is well. Attached, you will find the media list for this week.
Then, Your Honor, I take full responsibility for that. I can address it. If it was sent, then that is on me. If it was sent out on Sunday.
Okay, well, anyway. Luckily, the only person highlighted is somebody who's already been testifying, so it's not an issue for this time, but not have that happen anymore. Second, we do have a witness on the stand that we broke to handle Mr. Zachary for. So we need to be continuing with that witness and go ahead and finish up with that. In addition, you have even more last minute provided an updated transcript at what, 8:30 or 10 or something o'clock last night?
I don't have to use that. I can.
Okay, that's good because nobody's had a chance to be able to look at it or compare it or anything like that. So, okay.
And do you see that? Hilton's late. Love doesn't want to step up to the plate. They have to deal with that. And then they introduce something at like 10:30 at night. They turn something over. And again, this was back, I think this is like September. Let's check the date on this real quick. This was day 138 and September 30th, 2024. So that's where we are in this, at that point in time, not to quote Glanville. But right out the gate, she's just a hot mess, and she's using the soft voice. Whitaker seems like she's about to have a day, and a day she will have.
All right, so can we get Mr. Sprinkel over to finish up his testimony?
And you know
Yeah,
he's at the
Mr.
door.
Sprinkel So as I explained before, I called Mr. Sprinkel when we intended to call Mr. Zachary. Mr. Sprinkel's testimony, and in order to avoid him being called twice, we were putting in the interview of Mr. Zachary, given his continued pronouncements regarding his health concerns and other considerations. We were going to call Detective Gaither to simply get in the interview regarding Mr. Zachary. Mr. Sprinkel's investigation, if you will deal with some of the information that comes from Mr. Zachary's interview. And rather than asking the court to call Mr. Sprinkel twice.
Well, we're calling lots of witnesses twice, or you are calling lots of witnesses twice, so.
Your Honor, I'd ask the court's permission, since we do have Detective Gaither here, to allow us to put in Mr. Zachary's interview and to allow us to proceed after Detective Gaither with.
And what is Detective Gaither just going to be introducing the interviews?
She's going to be introducing the interviews. Primarily, that is the reason that we have her. She also confirmed, though Mr. Zachary was able to confirm some information about his phone number, another phone number. I told her that I don't expect to keep her very long. I don't expect her to be more than today, frankly. And yeah, that's it. And the other matter that I wanted to broach with the court simply dealt with the concerns that the court had that we broached briefly regarding some of the cross-examination testimony and some of the information in the interview with Mr. Zachary on the 5th of August, 2015, that we believe has addressed some of the concerns that the court had regarding.
I'm sorry, but I don't know what you're talking about.
So in my email to the court, I said that there were some matters that we would ask permission to address prior to playing the interview. Some of the portions of the interview that defense requested redacted, the court said that it needed sometimes foundational information before I went ahead and.
Okay, and I think that Ms. Persfield responded to everybody that we're not going to address that this morning before, and we know that the jury is going to be here and ready to go at 9, and I don't think there's going to be time to address all of that in the 5 minutes before the jury is here. Do you?
Well, there is one that I think we can. It's the first one that we have listed.
Okay, well, anyway, that is what I said we would address either at lunch or at the end of the day, correct? All right, and so for that reason as well, we're not really ready for Detective Gaither's testimony. So go ahead and call Mr. Sprinkel over and let's pick up with him, because we can't, if we need to do the whatever is or is not going to come in in the interviews, and it's different from what we had already made determination about, and we left some things for determination. We have to figure that out during the lunch break. So,
Yes, Your Honor. Will
All
the
right.
court permit me to step out and make that phone call?
yes, please.
And also, Your Honor, so will the court be permitting me or allow me to bring Mr. Sprinkel back after we get in the
I
testimony?
mean, it seems to me like that's been kind of the way this case has gone. It's that people get called back 2 and 3 times. So sure, you can do that with him too.
Excuse me.
So they end up taking a recess here. And, well, they handle other matters. But do you guys, I mean, just to sum it up real quick, Love knew that she wasn't going to put Quindarius Zachary back on the stand at this time. Sprinkel, who we have a running joke that if he's supposed to be somewhere, he is at the courtroom door, face at the window, ready to march in. There is no other witness that, when called, is ready to walk through that door faster and sooner and on call like Michael Sprinkel. And yet today, she's so insistent on having Gaither come in, and Whitaker's like, what about Sprinkel? What about Sprinkel? What about Sprinkel? And now she has to go make a call. And we know how many times the state has been yelled at for not having a witness ready. But they want Gaither to come on so badly to introduce these interviews because Quindarius Zachary isn't being responsive in the way they want him to be. And we might revisit all of Quindarius Zachary's moments on the stand because there are some moments. But that's the play. That's the play. She wants Detective Gaither, who will be wishy-washy on the stand. She doesn't want the media to show her face. In my opinion, she's saying it's because she's scared, but I think she just doesn't want to look like she lacks credibility in her facial expressions, even though it's pretty clear from her delivery she lacks credibility. It's just a play. So they do all this mess. They end up having some other evidentiary arguments. Did you guys want to watch the lunch? I won't put us through Sprinkel and direct with Love. We'll get pretty much what we need through the redirect. But if you want to watch the arguments during lunch, it is Love struggling line by line with different lines of transcripts of why she thinks that they should be able to come in through Gaither and or Sprinkel without being considered hearsay without an exception. So quick vote there. Cash Money Cass also says it's sending me that this is our bonding. We gather here again, yet again, to revisit the YSL trial. And Sprinkel in his laptop. So I think he still had his laptop this day, but that becomes an issue. I think this was like a Thursday or Friday ending out the week, but the following week, we end up having it pointed out that, hey, can you ask Sprinkel when he's back, like not to use his laptop? And that's why I think people were saying over the weekend, the defense teams had seen online that you guys were pointing out, hey, he's scrolling on his mouse when he's not asking or answering a question that would relate to something he needs to use his laptop for. So that was cool. I really think that was one of those two-way social media and trial dynamics where the course of the trial was impacted by what people observed through social media. So, hey, Angelica. Good to see you. I love Dark Lotus here using what a disaster this case was/is. It's both. It is both. And good to see you, Kate. I'm telling you, I really think it's interesting to watch her argue during the lunch break, these transcript issues, but it is also grueling at the same time because it was like 30, 45 minutes-ish of it. But you do hear Whitaker mention but that would be for the truth of the matter asserted. No, I'm not going to let that one in. So what the takeaway here is Love was already told during lunch she should not be trying to get certain exhibits in just for the truth of the matter asserted, because that's not going to get you past the hearsay rule. And then on redirect, we're going to get to redirect and see how that just does not get followed.
He was not in the Infinity, correct?
He was not.
Thank you.
Any other defense counsel have questions for this
AOG.
witness? No. Okay. Is there redirect?
Yes, Judge.
Okay, go ahead.
Good afternoon again.
Good afternoon.
You were asked on cross-examination by Mr. Adams whether or not you saw communication between Demise McMullen and Kenneth Copeland.
Correct.
Paul,
Yes.
what was the number that you were able to obtain for Demise McMullen?
So the number for Demise McMullen was 470-217-6080.
And you were asked as well about efforts that you made to corroborate information that you were given during specific interviews. Do you recall?
I do.
I'm going to show you what has been marked as State's Exhibit 528 Yankee. And ask if you recognize 528 Yankee.
Hey, Coco.
I do.
How?
This is a picture that I obtained from Justin Cobb's Instagram page that I screenshotted.
Okay. Why did you, let me ask you first, is 528 Yankee a fair and accurate copy of the screenshot that you got from Justin Cobb's Instagram page?
Well, yes, though it's cut off a little bit on the right, where the timestamp is, the last number of the timestamp, it just says 201.
Okay.
But I mean, I recognize that it's otherwise fair and accurate. It's just cropped a little bit on the right-hand side.
This is such a Sprinkel answer to a question like that. You know, you would expect, is it fair and accurate? You're either going to get a yes or no, or hey, something substantively has changed. He's like, the cropping's a little different.
Your Honor, the state tender states 528 Yankee as evidence.
I would actually object to it if it's not an exact.
If it's what?
I'd actually object to it if it is not as he remembers it to be, if it's been altered or if it's not the same that he's viewed previously.
Okay, well, it is admitted, subject to the understanding that the date isn't to be relied on because we can't see what the date is.
And I'd also object to any hearsay that may be contained within that document.
There you go.
I don't know if there, I don't know what the exhibit is. So is there, is that an issue I need to take up?
I don't believe so, Judge. I mean, I can show the court in.
Okay.
Right on the side, take a look at it.
Aaron remembers this day based on the color of the blazer. And I think this was, yeah, I forgot, right around this time, they weren't able to show sidebars anymore. So this is when we started panning to the seal instead of being able to like watch and speculate about the body language. Oh, I guess we weren't quite done.
Show you. And Mr. Sprinkel, I'm going to show you the digital version of 528 Yankee and ask you, are you able to see the date on the digital version?
I am.
Your Honor, state. Said there's 528.
Okay. So are you going to, it'll ultimately be, are you just going to make a better copy and substitute?
Yeah.
All right, that's fine. Then it's admitted in full.
Thank you.
Now, what we don't get to know about this sidebar, they have a printed version, they have a digital version, and it might be confusing going back and forth what is about to be produced. She's about to produce, it seems like a print version that they could give to the clerk to give to the jury and actually properly admit it into evidence. And we don't know how this is changing over time. And, I'm going to say my own opinion. Love has had a funny way of changing plea agreement versions over time and only being the only one with a copy of a certain version. So I don't know if I really trust her with this. We've also seen weird video replay issues, like when we were replaying the video in court of Antonio Sledge's plea colloquy. It mysteriously skips at a certain part, and then when she finds another way to play it, she moves the scrubber to where she should be starting it, and then moves it back forward to skip 2 key words. So I don't really know if I trust this reproduction back and forth that's about to go on here. Let's see what happens. Hey, positive Q.
As we're pulling up 528 Yankee, would you tell the jury what significance you found in 528 Yankee towards your investigation?
Well, there was a phone number posted it was a public post, and there was a phone number that was, there's a comment section to the right of the photograph, and there was a phone number posted by the account holder that appeared to be their own.
Okay. And was the account holder Justin Cobb?
Yes.
What was the significance?
I'm going to object to that as hearsay and ask it to be stricken.
Which part?
Part about who the number belongs to.
Sustained.
Okay. What did you do to determine whose account this was?
Well, I looked at the photos that were posted in the account, I believe. And now for the traditionally, that's what I would do with an Instagram page. It's just posted in public view.
Okay. And what was it that made the number in this post significant to you?
Well, I was looking for a number for Justin Cobb.
And what led you to believe that this number was a correct number for Justin Cobb?
Now, so she gets this phone number. Keith Adams objects on it being hearsay. Whitaker seemed like she wasn't really paying attention when she thought about it. In a stern voice, she said sustained. Now she's trying to rework her question to work it back to, well, maybe there was a process for you to go back and use this number as the detail that you found to be proof that this number belonged to Justin Cobb, which isn't going to get her around the rule.
Well, it was, there's probably more to it than just this, but it was posted in this Instagram comment, and
Posted by the owner or user of the account?
That was
Yeah.
false speculation. I'd object.
Yeah.
If he has a basis to testify.
Are you able to see and tell, looking at the posting itself, what name the number is next to?
I
What
would
handle
renew
the
my
number
objection,
is
also
next?
object on the basis of hearsay if he's reading from a document.
It's already in evidence, Your Honor. And,
Okay, when
Your Honor,
we were up here at the bench,
so, Your Honor, I'll
Hang her
ask
head.
additional questions that I think will,
sustained.
okay. So, after seeing this
Your Honor,
number,
I have a motion, please. May we step up?
Yeah. I'm going to excuse y'all to the jury room.
Sprinkel just going back to the computer. He's like, clickety clack, don't yak yak. Now, I don't think Whitaker was paying attention when this first happened. I feel like right there she was waiting for the motion for the mistrial from Adams, though. did you see Love's body language where she hung her head? To me, and maybe I will admit I'm probably looking for it, but to me, her body language confirms that she knew she was doing this. She knew she was going to just continue asking whatever questions, even though the judge clearly wanted her to move on in this moment, even though she was instructed during lunch when she asked for reconsideration, when this had previously been excluded, can you reconsider that I could actually get this in? No. And then whatever they discuss at the bench, which I'm assuming, I'm going to make the assumption here that at the bench they said, cool, well, you have this digital version and you have this print version, but Sprinkel's saying the print version crops out the date and this digital version has the date, but the digital version shows everything. And we need that number redacted. You can't just blurt that in and whatever. And they come up with a third version. They produce this digital version and a print version. And Love does the thing she's not supposed to do. Just insanity. And then she hung her head like, oops, tail between my legs. Look at them. Hilton's like, you always doing some BS. Like, why are you doing this to us? Ruining our case.
Your Honor, may we excuse the witness?
Yeah, Mr. Sprinkel, you can go ahead and step outside for us. Thank you.
Your Honor, so
Yeah.
well, first of all, my motion is a motion for mistrial based on the actions of the prosecutor. My objection initially to the item was that it contained hearsay. The state represented at the bench that it was not hearsay. There was no hearsay contained in it. We did not address the issue of what the state already knew, which is that there was a phone number attached to it that she was going to try to elicit testimony from this witness about who that phone number belonged to. That in and of itself is speculation, but it's certainly hearsay. The document can't authenticate itself. I believe the site for that proposition is Twiggs versus State. It's 315 Georgia Appeals 191. So this witness can't look at a document and say that it says this phone number is from Justin Cobb's Instagram or social media posting, this is who it belongs to. So that was my objection. I believe the objection was well-founded. I believe the state purposely put that up there after misrepresenting as to whether or not it contained any hearsay in it. And based on that, I would move for mistrial.
May I respond?
You may.
Judge,
Can somebody put the document up? I'm listening.
yes. Would you put it up? First, the state objects to a mistrial. Second, Your Honor, what Mr. Adams indicated that he did not want on here were the comments where's the phone number? There it is.
Yeah.
Okay.
The comments
Hold on. Where's the phone number? There it is. Is she for real? And I don't think I paid attention to that when we watched this in real time, but is she just pretending like, oopsie?
Adams indicated that he did not want on here were the comments where's the phone number? There it is.
Yeah.
Okay.
The comments generally being all of the writing on the right side of the picture.
Your Honor,
And so I said to you, is any of it hearsay? Is any of it being offered for the truth? And you said, no.
Your Honor, what I was asking the witness to do is to tell what was of significance to that number and what he did in terms of finding out and corroborating information that he obtained, because he obtained phone records. I don't intend that this evidence or this exhibit will prove or show that this is Justin Cobb's phone number.
You're asking him that? And
No,
asking
Your
him
Honor,
to testify to that?
I'm asking him, and I understand the court, I'm asking him
you?
what handle it's next to, and Your Honor, what he did after seeing what he saw on this
That's
social
not what
media
you
page.
asked, though. You represented at the bench that none of this, that being the writing on the right side of the picture, which we're all squinting at because it's tiny on the piece of paper. And so I am
Convenient.
relying upon you to actually be honest with the court and opposing counsel so that we can deal appropriately with the evidentiary issue. Was any of it being offered for the truth? And you said no. And then you turned around, and after it was admitted over the overruling of the hearsay objection, based on the representation that nothing was being offered for its truth, you drew the witness's attention to the phone number and tried to have the witness testify to whose phone number it was. If that is not offered for the truth, what is it?
Your Honor, it
What is it?
explains what steps he next took. It wasn't that he sat there and took this phone number and
Well, and I know Paige is she's clear here. She's clarifying exactly why this is an issue. But with Love trying to explain this, what was the order in which Love tried to do this? She tried to just have Michael Sprinkel read the comment and say that he, knew or whatever, that account belonged to the person they're trying to associate with the phone number, Justin Cobb. What happens the first time the objection from Adams is sustained? She ends up reworking and asking the same questions again. So for her to even try to levy this excuse is complete BS. Because if that was the case, and if she realized that's what was happening, we never would have gotten her trying those same questions again. So let's see how she starts off her response here to Whitaker. Look at her face. Oh, Whitaker. But she wasn't mad enough because she didn't grant a mistrial. So
Offered for the truth, what is it?
Your Honor, it
What is it?
explains what steps he next took. It wasn't that he sat there and took this phone number and said, okay, this is Justin Cobb's phone number. He went and sought records based on what he saw on this social media post. So it's not, this post can't prove anything, but I do expect that the witness will testify based on what he saw, regardless, because it's a legitimate.
Why can't you just, at the bench, when you know that the reason you're offering it is for the phone number, and then to ask the witness other questions about what he did based on that phone number and seeing that phone number, say to everybody so that we know what we're dealing with, it's this phone number, and then I'm going to ask him XYZ about the phone number, and then we'll know what we're dealing with.
Because my understanding that what was being objected to was not the phone number, was the comments that was the words, Your Honor. And again, this piece of evidence does not prove anything, as anybody would be able to say. But when he saw this on Justin Cobb's page, or a picture of Justin Cobb next to what he believed to be Justin Cobb's handle, he saw additional information. The entire cross.
Believed. But what was she having Michael Sprinkel? What testimony was she trying to elicit from Michael Sprinkel just a few minutes ago? She knew that he knew who the account holder was.
Comments?
I'm sorry, what, Your Honor?
I mean, that is included within what you're now calling comments, all of them just being.
And I asked at the bench what comments they were asserting was hearsay, Your Honor. I literally asked
I asked at the bench, is any of this being offered for its truth?
And Your Honor, it's being offered to explain DDA Sprinkel's actions that he took next. Your Honor, these records have been collected as part of what he did in this investigation. He was asked on cross-examination, did he take particular steps to corroborate what was given to him in certain interviews? That was the preceding question before I asked him about this particular post. So the state intended and intends to introduce the records that DDA Sprinkel produced or obtained after seeing this post. This post can't suffice to prove that that is Justin Cobb's number. This post only explains why DDA Sprinkel got the number and why it was significant to him in this investigation, where his steps and actions are being questioned.
But Judge, we don't get there. I hear what the state's saying, and it's disingenuous because we don't get to the second step that they're talking about, what records he procured and why he did what he did, unless we go through the hearsay statement that's contained why he's genuous. Because we don't get to the second step that they're talking about, what records he procured and why he did what he did, unless we go through the hearsay statement that's contained in the portion that I objected to. And the court is accurate. I was there and I asked for everything that was on the right side, all of the verbiage to be, I said that was hearsay. The state said it was not. It clearly is, because to ask him that specific question, I mean, listen, none of us are obtuse here. It is what it is. I think that the state was disingenuous about it. State's being very slippery in regards to their response to the court's questions. I think it's willful, and I think a mistrial is appropriate. And I'm asking
I can't figure out what it is. If it's disingenuous, if it is that, I mean, I don't want to malign the prosecutor standing in front of me right now, so I'm not going to say the possible things that it could be, but it is baffling to me that somebody with the number of years of experience that you have, time after time after time, continues to seemingly purposefully hide the ball to the extent you possibly can for as long as you possibly can. And I really don't want to believe that it is purposeful, but honestly, after a certain number of times, you start to wonder how it could be anything but that, unless it is just that you are so unorganized that you are throwing this case together as you try it. And I am sorry to say that, but this case is being made much more difficult for everybody because of the haphazard way in which it is being presented. I'm going to take a recess for a few minutes. I'll have a ruling when I get back.
Watching this in real time, chat. Do you remember when this happened? I don't remember how I acted. I put the clip, like the real time clip, in the description of this video. But I opted not to watch it with our old commentary because I knew there were pauses and I didn't want to have to watch us pausing and filling time. But oh man, this was a day. This was a day. And it's honestly kind of beautiful that this is when we used to just go to the seal and they weren't just lingering and showing what was going on in the courtroom, because it's just the silence. Let's see. Time traveling a little bit. The way she comes back to the bench. Yeah, we were like, is there going to be a mistrial? Wait, what? Tracy says, I remember screaming so loud my neighbor called. Yes, I mean, I only have the compilation clip, but I mean, whatever.
My message to taxpayers is it was an amazing time. We had 19 convictions. The community is safer. We made sure that we got the resolutions we want. If they're unhappy with sentencing, they should elect other judges.
They should elect other judges. Oh, sorry. I thought I queued it up to when they were coming back. Okay, they do come back like right here-ish, sort of. Yeah, for real. It's like when they do a play call, they review the tapes. They want to see if someone made it over the line before their foot touched. And both teams are waiting like, oh my God, this is going to make or break the game. That's how we were. Oh, I was off on this timeline, scrub. Let's go. All right, there we go.
All right, I'm going to deny the motion for mistrial. It's not as if...
Remember us when that line was said? She comes out, she says, I'm going to deny the motion. Oh, man.
the state couldn't have gotten the testimony in an appropriate way anyway. It's not like the testimony itself is that big of a deal. But I am going to, I'm going to exclude that statement and just tell the jury to disregard the statement and any testimony that had anything to do with the statement. So let's get Mr. Sprinkel back. Did you want to put anything on the record, or are you just getting ready for the jury?
I'd like to put just a matter
Go
before
ahead.
the record for the court.
All right.
Your Honor, this is from United States versus Roberts, Roberts. It's 640F second
Federal?
255. It's the Ninth Circuit, 1981. It's been cited many times. It specifically says that continued prosecutorial misconduct may show a course of conduct establishing the intent to provoke a mistrial and bring into play double jeopardy considerations. You have not been here the whole time, and we thank you for being here. But starting with opening statement, and I know you got my motion.
I know, and I know what your argument is. Here's the thing is that, and I understand what that law says as well. Ms. Love does not appear to be trying to get a mistrial so that she can try this case over again, which I know if that were what she was doing, she wouldn't be able to try the case over again anyway. So that's just not applicable here. Now, is there continued prosecutorial misconduct merits a mistrial anyway, based on that? Yes, potentially we get to that point at some point. But there is not, from what the court's vantage point is, an indication that the state is trying to goad anybody into moving for a mistrial so that they can retry the case because they think they're losing the case. I think they think they're winning the case.
My favorite part. Oh, I'm blocking the caption.
I
Sorry.
don't know what they think, but I will say this. This is not becoming in the state of Georgia of a trial. And it is all the time, Your Honor. It is all the time. At some point, it's got to end. Because this is not fair to Mr. Williams, and I assume the other people on trial will agree. It is this constant hiding walls, citing law that does not stand for what it stands for, not giving over information, not answering the court, arguing with the court, and I think that it does rise to a level now, but I understand what you rule. But I think that we're well beyond it. And the reason I said promotion statement is it's literally from the
Oh, I saw that. I know. I mean, I think my frustration was apparent a few minutes ago. But I truly am struggling with whether all of this is purposeful or this is just really poor lawyering on the part of members of the state's team. Either way, it's really unfortunate. If it's something other than poor lawyering, then it is more than unfortunate. But at this point, and we're going to just move on with that exhibit being excluded. I don't know if I can stress any more than I already have how much the state's lawyers need to make an effort to be upfront and forthright in the trial of this case. So let's get the witness back in.
Your Honor, would you allow me to either renew my motion for mistrial or consider that my motion is renewed before the asking of the next question,
Yes,
please?
it's renewed.
Thank you.
The Harvey rule does apply.
Yes.
Harvey rule. Look how quick Sprinkle just got in here. We still had things going on with motions, and Sprinkel's like, doop-de-doop-de-doop.
Motion is renewed before the asking of the next question,
Yes,
please.
it's renewed.
Thank you.
The Harvey rule does apply.
Yes.
Oh my goodness. So we'll watch a little bit more of how this redirect plays out now that that all happened. And then we've got 2 follow-ups that I think you guys will love. He's already clicking. Are we signing in? See, that's Angelica. That's not what that case said. That was my case.
Thank you. Ladies and gentlemen, upon further discussion, that last exhibit, which is State's Exhibit 528Y, is excluded from evidence. And so that means that y'all need to disregard it entirely in your thoughts and in your deliberation in this case. And as well, you need to disregard any testimony that might have been given about that particular exhibit. All right, go ahead, Ms. Love.
Thank you, Judge. DDA Sprinkel, you were asked on cross-examination about whether you attempted to determine whether Kenneth Copeland, in the words of Mr. Adams, lied when talking to the police. Do you recall that question?
Yes, generally, he asked me something about whether I endeavored to detect that or figure it out.
Did you make any steps to determine or to corroborate the information you gained from Kenneth Copeland?
I did.
Would you tell the jury what steps you took to corroborate information that you gained from Kenneth Copeland?
Well, there was a number of things that I did. I, in particular, looked at all the cell phone records. Like, for example, so I looked at the call detail records, the times that people were called or made calls, the parties to those calls, and also the towers that the handset or handsets utilized by those calls. And as I've testified previously, you can tell somebody's general location based on the tower and the sector of the tower, the antenna of the tower that their handset utilizes to facilitate the call. And also you can, in knowing who somebody is communicating with at a given time, that can tell you a little something as well. And so when I compared Mr. Copeland's statements to my analysis of the cell phone records, I tried to the best of my ability to corroborate as much of his statement as I could by analyzing all of that.
You were also asked on cross-examination the power went out over here. Just keep going.
Fine. All of the electricity went into her blazer.
On what? I can't see any of the screens, so.
They're black.
The monitors themselves are out? Okay, well, do we need them right now? Do we need them right now?
No, not at this precise moment, no.
So
It kind of looks like I guess his laptop would have a battery, but it looks like Sprinkle's hands are glowing and maybe his cheek a little bit. It looks like he still has his laptop battery going. So he's fine.
In terms of, is this one on?
No.
No? Okay.
No.
Do we have our backup thing? It does sound like something went silent too, so.
Just to be clear, Your Honor, it's not the monitors that have lost power. It's whatever's feeding the monitors.
Okay. Well, we got the sound fixed, and so now we're gonna have issues with the video, the site.
A breaker's.
Yeah, I think maybe a breaker got thrown, because it sounds like maybe the AC went out, which would make some people happy, I think. All right.
Always
I
just
mean,
Kate.
if it's going to be a few minutes before you get to the next exhibit, you can just go ahead with the testimony, and Ms. Pursfield will see what she can do about getting some sort of monitor back up.
Yes, thank you, Judge. DDA Sprinkel, did you utilize statements from other witnesses to corroborate information you obtained from Kenneth Copeland's interview?
I did.
Citation clause.
Not just from that, so overruled.
You were asked on cross-examination whether you obtained a wiretap for Defendant Williams' phone. Do you remember that?
Yes.
All right. As it relates to the Donovan Thomas murder, would it be something you would expect to be able to get a wiretap for a year and a half later?
I'm going to object on the grounds of speculation.
Overruled.
As it relates to the Donovan Thomas murder?
So wiretaps are for evidence of things that are going to be talked about in the future. I'm trying to think.
Already
I don't
wiretapping
believe
them.
I've ever obtained a wiretap to investigate a crime that happened in the past, solely to investigate a crime that happened in the past. That's not to say you couldn't. I have heard of such things, but I've not personally done it, and I did not do it in this case.
Thank you for the clarification.
You were also asked on cross-examination about the photographs that depicted, or the social media postings that depicted Defendant Stillwell. Do you recall that?
Yes.
And did you testify that you obtained information about the photograph from a person you spoke to?
Yes. Yeah. So apart from what was just available in the public internet form, that being the website from which I obtained them, yes, I did. I spoke with someone about the photograph.
Okay. Mr. Adams asked you about Detective Thorpe consulting with Detective Gaither and Detective Dennis. Do you recall that?
I do.
Do you have any knowledge of whether Detective Gaither or Detective Dennis were consulted
Book of
with
World
before
Records?
warrants were taken out by Detective Thorpe? In other words, did he seek their permission to take out the warrants?
No.
You have any knowledge about that?
No, I don't believe he did, no.
Okay. You were also asked on cross-examination by Mr. Adams about the dismissals and the NPGJ for certain people that warrants were initially taken out for the murder of Donovan Thomas. Do you remember that?
I do.
Were the dismissals of those warrants in any way based on the additional investigation that you did with your investigator, David White, into the murder of Donovan Thomas?
Well, no, not the one with Sledge. That was Mr. Antonio Sledge. That was the preliminary hearing judge that threw that one out. So,
did you?
Hang on.
It's not responsive testimony about other court proceedings.
All right, I don't know if your mic's on at all, but
I'm sorry, it was non-responsive and it was testimony about other court proceedings, which I believe is inappropriate and hearsay.
overruled.
Did your investigation into the murder of Donovan Thomas lead you to present MPGJs for people who had been arrested for his murder?
well, yes, for the people for which we didn't, the people that we didn't prosecute for the murder, yes.
Mr. Adams asked you specifically about corroborating the information you gained from Kenneth Copeland's interview. And specifically, he asked you about phone calls with Demikia and Garlington. Do you remember that?
Yes.
Are you able to tell the jury what information Kenneth Copeland provided you that you were able to corroborate?
Well,
Okay, I think your mic's still out, but sustained.
You were asked on cross-examination.
Hold on, did Love get louder in the microphone because Whitaker pointed out that Shart's mic wasn't on? She definitely got a little louder there.
By Mr. Shart, whether Kenneth Copeland said he was at the Green store at the time of the murder. Do you recall that?
I do.
When you are looking at cellular location information for cell phones, do you look at a static point in time to determine what a person's handset is doing? In other words, do you only look at the time of the incident in question, or is the time leading up to it and the time after it also relevant?
Well, yes, the times before, during, and after the homicide, it can absolutely be relevant.
Was there any point during your investigation where Kenneth Copeland said, I was at the Green store at the time of Donovan Thomas's murder?
I don't remember that. I don't have every single thing that he said during his, particularly the 9-hour statement, committed to memory, but I don't recall him saying that, being even cognizant as to saying that he knew exactly where he was at the time that Donovan Thomas suffered his fatal gunshot wound.
Okay. As it relates to what Kenneth Copeland did tell you about his whereabouts on the day of Donovan Thomas's murder, were you able to get information as it relates to any significant others in Kenneth Copeland's life about where he was on the day of the murder?
Well, so to be clear, I never spoke with Kenneth Copeland, but from the statements that he provided, yes, I believe so. I definitely because he would reference people that he knew, I sought to identify, for example, phone numbers for those people, because again, that would go to my corroborating his statement based on, among other things, his phone logs.
Okay. When you testified on cross-examination that you were looking at big things for inconsistencies, what did you mean by that?
Well, a big inconsistency would be, as I cited, if somebody were to say, for example, I witnessed a murder and there's a video of the vantage point that the person cited that they stood, and then I look at the video and there's nobody there, that would be a big inconsistency that I would seek to clear up.
That right there reminds me of Relly in the ASAP Rocky trial.
And indeed, I did that here. That's what I meant by that. Something that's glaring, something that you're not able to, something for which there's not a reasonable explanation that can clear this up for you.
Okay. You were also asked on cross-examination about who was in possession of the Infinity that was at the Texaco prior to the Donovan Thomas murder. Do you remember that?
Yes.
Why did you say, do you mean, or if you mean actual possession? Do you recall responding
Yes.
regarding actual possession? Why did you say that?
Well, the person that was actually like at the helm of the vehicle and had actual control of the vehicle, not the person that had some sort of legal right to the vehicle through a lease agreement or otherwise.
Did you see anyone else's name on the rental records for the vehicle, the Infinity that was at the gas station up the street from where Donovan Thomas was gunned down?
I don't know. I don't think so. Just Mr. Williams.
Okay. Mr. Adams also asked you about phone calls between Demise McMullen, Kenneth Copeland, and Demikion Garlington. In your review of Kenneth Copeland's interviews, do you recall him ever giving a specific time that he was in the car, as in 1 a.m., 4 a.m., a specific time that he was in the car with Demise McMullen and Demikion Garlington?
Well, it was afterward. But no, I don't recall the specific time, or if he cited a specific time. From what I remember, he would cite generally. He'd say, "Oh, I think it was around 10:30 or something." That's not a quote at all what I just said. But no, I don't recall him having like a regimented timeline. Like at 1927 hours, we went to this location or anything like that.
Okay. You were also asked about the absence of phone calls in the phone records that you obtained as it related to Defendant Williams and Demikion Garlington. Do you remember that?
I do.
Okay, so Jim is saying that in their initial lyrics motion, they claimed that it was Thug. It was Jeffrey Williams that rapped the beat a murder rap, paid my lawyer $30 for that. There's two glaring issues with this. One, Jeffrey Williams consistently uses a very distinct, his sound is very distinct. So if they couldn't tell the difference, I mean, not that we need more reasons to doubt the way they analyze the music and lyrics in this case and to use in this case. But how do you confuse Young Thug's voice with like literally anybody else? But two, if the whole purpose we see later in the trial, they're using the same lyric to say, yes, Shannon Stillwell was saying that because he was referring to how he paid a lawyer to beat a murder rap. And if you're saying you beat a murder rap, that can only mean that you were actually guilty of it. Where, not for nothing, but if I'm acquitted of something I didn't do, I'm still going to say I beat the charges. Beating the charges doesn't mean that I got away scot-free for something I actually did. How are you going to say initially that you want to use these lyrics against Jeffrey Williams when Jeffrey Williams didn't previously have a murder charge at all? Brett, I'm so sorry. Brett says, oh no, this prosecutor drives me nuts. Can we just show cross exams? We've done some cross exams. A lot of cross exams are really the dismantling of Love's stories. And I think yesterday, guys, seriously, one of the favorite things in these rewatches, I never heard Carrington Matthews after Love chose to do a redirect, right? You don't typically see that. We saw it a lot in this trial. She did a redirect and ends up having Captain Pettis, the guy who was on the field patrol for like 6 months before he got promoted to do something else. She does a redirect to try to establish, did you or did you not recognize a specific gang sign coming from Chontavia Stevens and or the other individuals that you encountered that night? And this Captain Pettis can't get his story straight. He doesn't know the gang sign. He never put the gang signs in his report. The first time he's mentioning gang signs is when he's testifying in relation to this trial. And she's trying to push him to say he knew that it was a gang sign. And he's like, well, I don't know it was a gang sign. Or, yeah, I knew it was a gang sign. Well, how did you know it was a gang sign? Well, I don't really know. I wasn't educated at that point in time. And then Carrington Matthews gets up. Did you have any training at the police academy on gangs? Probably was the answer. And that the recross that we never would have had if Love wasn't trying so hard to get some answer or clean up some inconsistency from a bad witness. We never would have gotten that beautiful moment where one attorney with one question has this officer not even know if he took training on something that he's testifying about. Just crazy. Just crazy. And that Are You Certain day was from the same day with a different witness. That was with Monheim, I think. Right? Was that with Monheim? Just a hot mess on day 4 of this trial. Let's see. Let me pull up. Let's get the, let's see. We have Jim sending us the goods. Oh God, this is zoomed in all weird. So we have from Jim here, this is the motion back in October of 2023. So we're time traveling back quite a ways. It's the state's particularized motion in limine to admit evidence of lyrics at trial. The state of Georgia, by and through its counsel, Fani T. Willis, district attorney. Couldn't they have just put this over in discovery and identified that they plan to use it? Did they need to make this a motion in limine? Okay, whatever. But Fani T. Willis, district attorney for the Atlanta Judicial Circuit, and the undersigned Chief Deputy District Attorney Adrian L. Love, all the capital letters, hereby particularizes its previously made motions to admit evidence of lyrics at trial. Okay, so we're okay. In support of this motion, the state shows the following. The state will introduce evidence of the release containing the words listed below at trial. This is the I Just Beat a Murder rap. Paid my lawyer $30 for that. Jeffrey Williams. They don't even, so they're saying this is his song? They're not even just mistaking that he had some feature on it and thinking that that one line was him. They think that this is his song. You could easily go and look up the song and say, hold on now. Let's look up this track information. Let's see. August 2021. That's going to give me like, let's see. Let's go to like, what do you guys think? Like Lyrics Genius or something? But those sites will tell you. Okay, so we pull up the song. And let's do a quick check. Let's say we want to just go and verify some things. I'm searching for the word murder. It's not taking me anywhere. Like, why couldn't we have someone do some research and check the song? Did we just pick a random song name and expect the court wouldn't verify it? That's crazy. Oh my goodness. I'm yelling at the computer. Every time we talk about some mess in this trial, I start yelling at my screen. And coming back over here, Lauren Victoria Burke is in the chat. Good to see you. You guys know I've talked about LVB. Sometimes I shorten her name in reference. Lauren Victoria Burke does great coverage of, beyond trials. Let me get her channel link. Lauren Victoria Burke. One of my favorite things about LVB, she has a background in communications and crisis management. So her delivery when she puts together videos, really clear, really concise. And if she's going to tell you, hey, we're going to go through the 7 blanks of blank, she's going to give you 7 different things to know. And it's never clickbait. So thank you for the super here, Victoria. Good to see you. Hope you are doing well. And LVB, link in the chat there. Don't ask why we're revisiting this trial. We started doing this weekend, and now we're doing this to ourselves again. Here we are. And big thank you, Jim, for that page citing that. Like, that's just crazy. Okay, and it's not even a full song. It's just a snippet from that video outside the food mart. Oh my gosh. And then they end up having the snippet. So how did they not have the snippet a while ago and they just made up where it came from and then found the snippet to correct themselves when the defense maybe pointed out, like, hey, that's actually not from this is from that. I just don't understand how they got there. Oh, and factualizes since the power went out on these monitors. Love's jacket has dimmed a little bit. It has. That could be the camera adjusting. Crazy. Oh, and sweet. So apparently, according to the chat, YSL could have some activity this week. So let's keep an eye on that.
Are you able to tell the jury whether the phone records or the call detail records that you obtained would reflect FaceTime calls?
No.
Would those call detail records reflect WhatsApp calls?
No.
Do you know, or can you even say that there was no communication between Defendant Williams and Damikian Garlington?
No, I can't say that. The records, like I said, the call detail records are only those that were logged by the cellular phone company. A FaceTime call would be facilitated through Apple, the Apple Corporation's platform infrastructure, rather.
Did you ever charge Defendant Williams with Donovan Thomas's murder?
No.
You were asked about the headliner in the Infinity, or obtaining gunshot residue from the Infinity that you found a year and a half later in a different state. Do you recall that?
Yes.
Did you have any information about the number of people who had been in the Infinity between the time that Donovan Thomas was gunned down and the time it was located in a different state?
No. And from what I recall, Hertz wouldn't have been able to provide me with records of that anyway. It's very interesting. I couldn't ask for the rental history on a specific vehicle. I could only ask for the rental history of a specific person.
And did you have any information about the number of times the interior of that vehicle had been cleaned, laundered, or anything else in that year and change?
No. Not that I recall. No.
Without that information, why then did you seek to obtain a search warrant?
Well, I primarily wanted to obtain the data from the vehicles, the Infinity's infotainment system, the system that you might hook your phone up to. I thought that if we were able to get a search warrant, we might as well also analyze the interior for gunshot residue. I mean, I was aware of what the probative value of that may or may not be, but I thought better to have it not needed than the other way around. So that was the rationale there as to why I did that, or was contemplating that. That ultimately never happened.
Mr. Adams also asked you about not getting cell site data for the phone number that you determined belonged to Demekion Garlington, or at least that you testified on cross, was Demekion Garlington's phone number?
Well, I don't know that I definitively figured out that that was Demekion Garlington's number, no.
And what information could you get without having probable cause to obtain cell site location data?
You can obtain the subscriber information. That is the information that the phone company has on file for the person that pays for the line, if they have that information on file. The person that they would bill on a monthly basis, basically. And also the what are called call detail records. These are just, these are anybody who's had phone service, and they've seen a bill and it has a list of your phone calls, but that's essentially what this is. It looks a little bit different when you get them pursuant to a legal process like this, but it's just a list of the incoming and outgoing calls and text messages, not iMessages, incidentally, not messages sent between iPhones, but text messages, SMS messages. And that's essentially it. Notably absent from records, call detail records, if you don't have a search warrant, in other words, there wasn't a finding of probable cause, is that tower location data that I've testified to. That is the general area where the handset was, the equipment to which the handset connected to facilitate the communication. Without a search warrant, you cannot get that. You can only get the dates and times of the calls and the numbers that were that were part of that call.
And talking about the lack of calls in those records between Defendant Williams and Demekion Garlington, if two persons or two handsets are next to one another, do you generally expect to find phone calls between those two people if they're sitting, for instance, in the same vehicle?
Well, it's not impossible to call somebody sitting in the same vehicle as you. So I don't know why somebody would call somebody that's saying that. Maybe they can't find their phone. I call my phone, I can't find it. There could be any number of reasons. I can't speculate as to why you'd call somebody in your immediate spatial proximity.
Who was it that gave you the information about the photograph where Shannon Stillwell is depicted?
Quindarius Zachary.
And who was it that gave you the date or the approximate time or date that the photograph was taken?
Quindarius Zachary.
And finally, you were asked about the length of time people remained in jail after being arrested for Donovan Thomas's murder. Do you recall that?
No, I don't recall specifically being asked about the length of time they spent in jail, but I recall being asked about something along those lines, similar to that maybe.
Okay. If a person is held on something other than the warrant for murder, would an MPGJ or a dismissal of the murder charges automatically allow them to be released?
No.
That just seems like they're telling on themselves there a little bit.
All right, just 1 second.
Sure.
That's all that I have at this time.
All right, is there any recross? All right.
All right, you guys want to watch recross? I feel like we're invested in it. We had multiple voices say, yes, we want to recross. So I say we go for it. Her redirects get quite long to not really accomplish all that much. I think Hal has summed it up in the chat. We're actually getting it elicited further that the work Sprinkel was doing. And Sprinkel's the one that's supposed to be coming in and cleaning up the crappy job of the investigators that did all of the interview work before stuff was put on his desk. He's supposed to be the one cleaning that up and doing it better. And not only do we hear that stuff was so mismatched and uncorroborated that we end up changing who was charged with things, but we still end up having Sprinkel come up here and say that he's not supposed to speculate while also saying he speculated. So not really sure this was I don't know. I feel like if we went through and ranked her redirects on which actually helped redirect anything, the vast majority would be no, that was not helpful. So we got a hell yes here from factual lie. All right, we're doing the recrosses.
Mrs. Sprinkel, picking up where the prosecutor left off in regards to that NPGJ. What we do know, though, is that Mr. Copeland's NPGJ, the charges or the document that dismissed the murder charge that first put him in jail in 2015, that NPGJ wasn't done until 2017. Is that correct?
That sounds right. I didn't file that, but, and I don't recall who the prosecutor was that did, but I was aware of it. But I don't know that he was ever actually booked into the Fulton County Jail on the murder charge, though.
You don't know that?
I think he was in the federal jail, if I remember correctly.
The other three were, though, right?
Well, not Mr. Sledge, Mr. Garlington, because like I said, Mr. Sledge's case was dismissed in January 2016. Mr. Garlington, Mr. Jackson, aka Mr. Stillwell, yes.
Well, let me ask you this. You said Mr. Sledge's charges were dismissed in 2016. Where was he before his charges were dismissed?
Fulton County Jail.
Right, so in jail on that murder warrant, right?
Correct.
Okay, so he was in fact imprisoned on Thorpe's murder warrant until until his charges were dismissed, right?
Well, in the jail, not prison, but yes, he was incarcerated, yes.
Okay, I mean, jail, prison, you're not on the streets, your freedom's taken from you, right?
Right, I mean, it's a distinction without a difference. I'm just saying that, prison and jail are two different. Yes, his freedom was restricted. He was not allowed to leave. He was in a government facility.
You were asked a number of questions about cell phones.
Mm-hmm.
And I wanted to kind of pick up there. Now, you were aware from the work that you had done on the case, as well as listening to Mr. Copeland's statements, his interviews, that he had multiple cell phones in January of 2015. You're aware of that, right?
Mr. Copeland did?
Mr. Copeland, yes.
I'm sorry, I have one number for him. I don't recall him saying that he personally had multiple cell phones. I don't remember that now.
How about this? Do you remember in an interview that he had with the detectives where on January the 11th of 2015, at about 3:30 in the morning, where he talks to the detectives about his cell phone or cell phones? Do you remember that?
No, I don't recall that. I know I'm familiar with that interview, but I just don't remember him talking about multiple cell phones or anything like that.
Okay. Are you aware that there are no calls? And if we're just going to just talk about the number that you're familiar with in regards to Mr. Copeland, let's focus on that one.
Okay.
Right? Are you aware that there are no calls from Mr. Copeland's per his cell phone records on January 10th, 2015 between 6:58 p.m. and 7:26 p.m. Are you aware of that?
I don't have the full records in front of me. I do see that the records that I examined, the last relevant call is at 6:58 p.m.
Okay. And you had, when you got his phone records, we've talked before about the fact that you've got the cell tower data. So you had some idea of where you thought he was at particular times based on those records, right?
Well, I take that back, actually. At 7:01, 7:23, 7:24, 7:26, 7:28, 7:43, 7:45, 7:49, 7:51, and 7:54, there were calls.
Calls coming in or going out?
Let's see. There was an inbound call at 7:01. There was another inbound call at 7:23. There was an outbound call at 7:24. There was an inbound call at 7:26. An inbound call at 7:28. An outbound call at 7:43. An outbound call at 7:45. An inbound call at 7:49. An inbound call at 7:51. And that's it.
Okay. And so having his records, knowing the cell tower data, you were able to opine on where he was at a particular time on that night, January 10th, 2015, right?
Well, his general, the part of town, basically, that his handset was located.
You placed him, according to your report, either at or near the McDonald's on the evening of January 10th, 2015. You remember that?
I do.
All right. Now, you don't have any cell phone or cell tower data records on Mr. Copeland that shows his phone going to what we've called the Sky House on that night, do you?
I don't recall that. Yeah, I don't believe so.
Nothing in your records that refreshes your recollection that you've got any of that. You don't have any of that to show that he went to the Sky House or his phone, the phone that you're saying is his, went to the Sky House on that night. True?
That is correct. I don't believe that. Yeah, just taking a look at my notes, doesn't appear to me that I found that his phone traveled to the Sky House.
And one of the things that you were asked about these phone records, I think the prosecutor asked you, well, the phone records won't show you WhatsApp communications, right?
That's correct.
Asked whether or not the phone records would show you, or said that they would not show you FaceTime communications, right?
Correct.
And so I think your answer, tell me if this is what you said, was that you can't say that there was not any communication between Mr. Williams's phone and, for example, Mr. Copeland's phone on that night. You can't say that because it could have been maybe WhatsApp or FaceTime, right?
Yeah, some sort of platform for which we just don't have logs.
Right. And so what we have ultimately is that there is no evidence, none, right? Because we can't assume a negative.
Mm-hmm.
There is no evidence that there was any communication between those phones on that night, right?
Correct.
Prosecutor asked you, said, you never charged Mr. Williams with Donovan Thomas's murder, right?
That's right.
You did not.
That's correct.
Because you had no evidence that he committed that murder, true?
Well, yes, but I also can't charge people with crimes. I'm not a police officer and I'm not a grand jury, but I think I understood what the question was intended to elicit. And yes, that's correct. I didn't think that there was evidence to charge him.
You, I got a question about a video. I'm not sure if it was a prosecutor that asked you or whether maybe it was Mr. Short who asked you about a video, specifically at the McDonald's. You didn't get any video from the McDonald's, right?
I did not.
Okay. Are you familiar with different recording systems where there's something recorded and it's kept for a certain period of time and then either recorded over or deleted? You familiar with that?
Yes.
Okay, I think we talked about that you talked about that a little while ago, right?
Yeah, basically that there's only a finite amount of recording space, so eventually the recording has to start over again.
Now, when we're talking about...
Look at Love like celebrating, like, yeah, just keep it short like that. Look at her finger.
Basically that there's only a finite amount of recording space, so eventually the recording has to start over again.
Now, when we're talking about that, the recording starting over, you said before that some recording systems record for a certain period of time and then maybe a day, maybe a week, maybe 2 weeks, something like that. You remember that testimony?
Yeah, depending on the size of the recording, the size in megabytes of the recording media. I mean, presumably they don't have them on tape anymore. Yeah, it would depend on that.
Right. So if you've got, and not hypothetically, but just based on your knowledge and your experience, right? Mm-hmm. A system that records every 2 weeks. It's not that you've got 2 weeks of recordings, then all of a sudden that goes away and it starts over, right? Isn't it just that you have one day and then a particular day is taken up by the following day as it starts and goes all the way through? Do you understand what I'm asking you?
Yeah, I think I understand. It's a hard drive that the data is being written to. So, I mean, I don't know that as the drive fills up, you're right. I guess what you're asking is that after 2 weeks, does all the data just immediately go away at the 2 week mark? No, I wouldn't think so. No, I would think it would be an incremental deletion.
As it relates to this, if there's not knowledge, I would object based on speculation as to any particular.
Sustained.
Okay. All right. Mr. Sprinkel, you were asked, I think following up on a question I'd asked you, then the state asked whether or not you were aware of if Detective Thorpe consulted with Detective Dennis or Gaither. Remember that question?
Yes.
And we had talked earlier when I questioned you originally on cross about the fact that you knew that there were interviews, for example, with Mr. Copeland, where all of those detectives were present, right?
Yes.
And those would have been things that took place after January 10th of 2015, correct?
Yes.
As the murder investigation was being conducted, right?
Correct.
Okay. Then we have the arrest of these 4 individuals on October 20th of 2015, right?
Correct.
Okay.
Well, I don't know that they were all arrested on that date, but that was the date the warrants were obtained.
Got you. That's the date that Detective Thorpe made a decision, and I'm gonna arrest these 4 guys or get a warrant for their arrest, right?
That's right.
Okay. Which he was wrong about, right?
Well,
Yeah.
Sustained.
Okay. You were asked whether or not you thought that, or you knew whether Detective Thorpe sought permission from either Detective Dennis and or Gaither to swear out the warrants for the arrest of the individuals in the Donovan Thomas case.
yes.
All right. I think your response was either you don't know or you don't think he did.
Well, no, I don't think he did. That'd be very odd. The permission lays with the magistrate judge or a judge, not with his coworkers at the Atlanta Police Department. But to my knowledge, no, that never happened.
But what you do know, from speaking to the detectives, and by the time you grab a hold of the case, right, is that certainly Detective Gaither and Detective Dennis had been involved to some extent in the murder investigation, right, or at least assisted with it, right?
Yes.
And after Thorpe swore out the warrants in October, they were aware that these 4 people were sitting in jail, right?
They were.
Neither of them, these 2 seasoned investigators, either came to Thorpe or you and said, hey, you know what? We got some problems here. I think we got Detective Thorpe didn't do what he was supposed to do. We need to take another look. That never happened, did it?
Objection, relevance, and vague and compound.
Sustained.
Okay. In regards to the infinity, we talked initially, I questioned you, not talked, about possession of the infinity.
Mm-hmm.
And you used the word actual possession.
Right.
Right. You said, no, I do not know who was in actual possession of the infinity on January 8th, 9th, 10th.
Right.
Fair? Okay. And you were just asked a question about the importance of actual possession. And actual possession is something that's important to you or was important to you in making a determination about the infinity, right?
Yeah, that's right.
Right. Mr. Williams's name appears as the person who the car was rented to, right?
Yes.
Right. Now, in terms of your investigation, if you believe that there was something that was done or crime committed using the infinity, right, that is why it would be important to determine who was in actual possession of the infinity at the time that the crime was committed, right?
That's correct.
Because I can rent a car and it be in my name, but if someone else has possession of the car and is committing the crime, they're the person that's committing that crime, right?
That's correct. I mean, unless I were able to show that somehow the people that actually possessed the car did so with the encouragement of the lessee. But yes, you're right.
And specifically in regards to this case, this infinity, Mr. Williams, you had no such evidence. True?
That's correct.
Your investigation, I use the term investigation, your work on the case led you to recognize that there were inconsistencies and you couldn't trust what Kenneth Copeland was saying or what he had said in his statements. True?
Well, no, I thought that his statement, there were a number of things that I thought were accurate about his statement.
And some things were inaccurate, right? As far as you knew.
You would have to, his statement was there was a lot in his statement. I tried to look at his statement generally based on what he was able to remember when he provided that 9-hour statement, and primarily compare it with the phone records. And when I did that, I didn't see any glaring, I can't recall seeing anything that was just wholly inconsistent or impossible. Like, for example, the first witness, Spencer Wright, what he said happened was impossible. He wasn't there. I didn't see anything like that with Kenneth Copeland.
Did your investigation on this case, by the time you picked it up or got involved in it late 2015, 2016, seeing everything that had been done or not done thus far, also lead you to believe that you couldn't necessarily trust the investigative work of Thorpe, Gaither, and Dennis?
Well, no. I mean, yes, there was a mistake. Detective Thorpe made a mistake in not taking a look at the video and checking to see if the witness was actually where he said he was. Okay, but would that mean
Pretty
that
big mistake.
I wouldn't be able to trust anything in the entire investigation? No, I wouldn't make that sort of blanket condemnation such that I would just disregard everything in the entire file and every finding of fact made by the police. No. I mean, I can see that a mistake was made in one part of the investigation, but there are other parts of the investigation that were not as erroneous.
Not as erroneous. What kind of rehabilitation is not that erroneous? Oh my gosh.
Yes.
That's all.
All right, any other defense attorney have redirect? I mean, I'm sorry, not redirect, recross?
No, Your Honor.
Okay. Okay. All right, Mr. Sprinkel, thank you for your time. I think it sounds like we might see you again at another stage in this case, but you are free to go for now.
Thank you, Your Honor.
And it's a little after 4. Do we have another witness who's going to take hour and a half? If not, we'll just get started with somebody and go as far as we can.
We'll get started with Detective. Yes.
All right. Anybody need a break before we get to the next witness? Y'all good? Okay.
Your Honor, and as it relates to this particular witness, there has been a ruling as it relates to filming.
Can't show her face.
Okay, so no filming of this witness. Thank you for that reminder.
I don't remember exactly what happens after this moment, but it looks like Shart and Steele both have an issue to raise. So we can see how they argue
All right,
whatever they're
go
going to
ahead and
argue
get
about.
A quick bathroom, like 5 to 10 minutes.
All right, they want a break.
Okay.
And thank you.
You're the one who also wanted the restroom break, but I can listen.
And thank you. So, Your Honor, I'm objecting to a wholesale playing except for what the court redacted from Mr. Zachary's August 5, 2017, 2015 video audio recording interrogation, and there's Georgia cases that I have at my fingertips as well. But the first one is L as in laughter, K as in kitten, L as in laughter versus Ellington, ELLINGTON. Your Honor, it's 2018 United States District Court, Lexus numbers 208774, decided December 10th, 2018. And in that case, the district court wrote that the trial court ruled that because AL's statement during its CAC, but Child Advocacy Center interview were hearsay, and the prosecution had not introduced the interview, counsel could only introduce those portions of the interview where AL made an inconsistent statement, not the entire interview. And that's what I'm saying. Here the state, and I raised this at your bench 3 times. I said what I foresee is that the state is not introducing the interrogation, either one, there were 2. They're going to not use Mr. Zachary, and they're going to put it up with another witness. And you said, we'll see what happens. We'll see what happens in the future. Well, that's exactly how it played out. And it is my opinion that if there are true
Inconsistent statements, there's really inconsistent statements.
then I understand that. And it comes in under 24.801 D1A, because it would not be hearsay, because it would relate back to OCGA 24-6-613, prior inconsistent statement. But the state does not have a Kenneth Copeland where he would just say, yeah, I don't remember if I said it, but I lied. They have Mr. Zachary saying, I said that. I'm a liar, but I said that. And that's different than the just, I'm a liar, I don't remember, I don't recall. So unless the state can go piece by piece on what is an inconsistent statement, I'm objecting to just having a trial by prior recordings. The state then puts it on the accused and said that, well, we objected to it taking so long to the state going through the entire interview. The state was asking about, how old are you? Do you have a brother? Where do you live? I mean, all this just page by page, but they did not hit the specific statements that are now deemed inconsistent statements. And I'm objecting to the wholesale playing of a recording and the witness is gone. That's my objection. I have a Georgia case too, and that is Gibbs, GIBBS versus State 340, Georgia Appeal 723. It's in Division 2A, as in Elisa, 2017 case.
All right, thank you. Ms. Love.
Your Honor, I believe that the court accurately
That was a lot of yellow coming on the screen. Look at this swath of yellow.
Your Honor, I believe that the court accurately surmised that the testimony of Quindarius Zachary was given the way that he testified and what he testified to, much like with other witnesses in this case, he has set up where he has denied with the state information that he gave in the interview. He has claimed to not recall information that he gave in the interview. He has claimed to have lied about specific information that he gave in the interview, even to the extent that when asked identical questions by opposing counsel, he would give a completely inconsistent answer to opposing counsel. For instance, do you know this person? To me, he would say, I can't recall. 5 minutes later, to Mr. Steele, he might say, yes. Or to me, he would say, I can't read. 5 minutes later, he's reading a book placed in his hand. So, Your Honor, I think that the court had it right. I would ask that the court allow us to present to the jury this pertinent information and relevant evidence.
All right. Yes.
I just respond. The part I disagree with is the state has already presented this evidence. When he's asked, did you say Shannon confessed? And he says,
impeached him then.
yes, I did tell the police that, but that was a lie. They've gotten that information out. He has confirmed that he told the police that back in 2015. And that's the whole point of using extrinsic evidence, as I understand it. The whole point of using extrinsic statements or prior statements to prove the point is when the person's denying it and you have to bring in that statement. I'm sure if we look at the transcript, there are going to be a few times, especially towards the end of, I believe, the second day where Mr. Zachary was frustrated and got into I don't recall mode. But other than that, he acknowledged what he allegedly said and said it was a lie, and this is why I lied. And I don't believe that lays the foundation for what the state wants to do.
Okay, so I think that by and large, he said a whole lot of I don't remembers and a fair bit of, if I said that, I don't remember saying it, but if I did, I lied, to the extent that the statement itself can come in as substantive evidence as a prior inconsistent statement. And if the defense has particular parts of the statement that you believe that actually were sufficiently handled such that the extrinsic evidence of that shouldn't come in, then please let me know. But I think by and large, it can come in, subject to the redactions, of course.
Can I respond to your request? He certainly acknowledged making statements about Mr. Stillwell allegedly confessing in both statements. And the reason I can remember that is because I went through them and talked about how they differed. But that was standard impeachment comparing two statements, but at no point did he deny making those statements. So I think that's pretty clear that he did not deny those. He also did not deny giving when I believe it was Miss Love leading, or I shouldn't say that. Miss Love was asking questions and getting into alleged facts that Demekion Garlington allegedly said. I believe that Mr. Zachary acknowledged telling the police about that as well, except he just said that, Garlington was a play. Garlington had given him the play was his ultimate explanation, but I don't believe he denied that either. So I think, sure, there's a lot of tangential points that perhaps a foundation was laid, but on the main points as it relates to Mr. Stillwell, at least, I don't believe that he denied making those statements, and therefore I don't believe it's appropriate to play the prior inconsistent statements because they're not inconsistent.
By the same token, Your Honor, he also did not deny having said in his previous interview that Mr. Kendrick had admitted to being involved in that murder. He said that it was a lie, but he did admit to having said that.
All right, I'll consider those over the break.
Your Honor.
One more, Your Honor.
Yes.
He admitted that Jeffrey Williams, that he said, I'll say it's true, that Jeffrey Williams gave the infinity vehicle to Shannon, allowed Shannon Nard throughout the gap to drive as well as Mr. Copeland. And he was never even asked about giving Jeffrey Williams a gun, so it can't be inconsistent. He was even asked about that. Those two items I object to.
Asking about giving Jeffrey Williams a gun.
Yeah,
Give me a little bit
and it's in his statement to the law.
about Zachary giving Jeffrey Williams a gun.
Yes. But he never was confronted about that.
Okay.
Your Honor, now that I think about it, he also acknowledged giving the statement to law enforcement about, yes, he acknowledged giving the statement to law enforcement about Mr. Copeland being at Big Boo's house and then saying, let's go, and then returning and learning that there was a price paid on it. He acknowledged saying all that. He said he made it up, but he acknowledged saying all that. And he also acknowledged telling the police about what he observed at the Lil Wayne bus shooting when he was at Club Compound and cars leaving from there. So all those things were touched upon on his direct and acknowledged by the witness.
Your Honor.
Yes, ma'am.
Saying that he told the police that and then saying, but it was a lie, makes the prior statement an inconsistent statement. Additionally, he said to the state, I was high on, or I was withdrawing from 3 or 4 different drugs, depending on what time he was talking about it. So his intent was to suggest to the jury any way he could that anything he said about and I specifically asked because anything he said about either of the 3 defendants in this case that he talked about, he denied were true. Everything.
Okay. Let's take our 10-minute break, which at this point will bring us back at 4:30.
She said, let's just take a break. And yes, we did skip a portion, a good deal of today's testimony, but I gave you the summary that during the lunch break, they were arguing about the admissibility of line by line different statements in these transcripts that they want to introduce through Gaither. Now that Quindarius Zachary is not on the stand right now. We started off this day. The very first thing she says is, Hilton had traffic, and then we want to bring Gaither on. We want to bring Gaither on. Well, what happened to Sprinkel? I thought you were in the middle of Sprinkel. So the big picture goal, and it's very obvious to me, but Love won't just come out and say it, is it's been her plan all along to have Gaither play the interviews that the state wants to use to make the defendants look bad, when the witness who's actually saying the statements is no longer on the stand. We'll get them in through Gaither, who will answer our questions however we want her to answer them. And then on cross-examination, she'll be hostile and deny everything to the defense attorneys crossing her. So we'll clean up. We'll get when they come back in, we'll see how they finish out the day. I don't imagine they get through much more, but we'll round out this saga and then see what happens a few days later in relation to this.
Steele, the reference to Quindarius Zachary either providing or not providing guns to Mr. Williams?
One gun, yes.
A lot of paper searching. Jeffrey's just looking over there like, doo-doo-doo.
Yeah, I'm really thinking it's 4:35 right now.
All right, they call this quits.
Can you go ahead and let the jury go for the day? We'll see them at 9. We can just discuss some evidentiary issues for the rest of this day. Things. Just grab their blankets and things.
Ask what time we'll start.
We will be starting at 8:45. Can't somebody else do that? Because I'm waiting for Mr. Steele to get the reference, so I think you need to be here for that. Somebody else can go say that. But the witness needs to be here at 9. What is it, Mr. Steele?
I believe it's on transcript page 149 of 275, line 16, and it's a lot of unintelligible. This transcript's not, it's unintelligible.
No, it's not.
When I listen to it, it says, I told Bud and stop messing with everybody. He might buy no guns for no crime. So I know it doesn't sound bad, but I believe that later they say that he bought a gun for Jeff. And that's all I'm looking for.
Later, there's.
The whole team trying to get Steele a
If it's
mic.
not there, Your Honor, then that's the only reference.
Any response on that? I mean, I don't recall that witness being asked anything about that, but it's not really saying anything anyways, is what Mr. Zachary's saying.
Yes.
Judge, I know that the line 19 is out, and I just asked that the court allow us to play it up. What I have is that he said, I'm looking at it. I know that I disagree with with Mr. Steele about it, this particular sentence needing to be put on him. He said everything he said about each person in this courtroom is not true. And so
Is that true?
This is not one of the redactions that were previously ordered. I think
Hang on.
it's admissible, and I'd ask that we be allowed to play up until line 18.
So that's not Zachary saying anything about Mr. Williams, right? It's just him saying, here's what I said to Mr. Williams?
No, it is that Mr. Williams didn't have any buying guns to commit
Hang
a
on.
crime. Sorry.
Okay, go ahead.
Mr. Williams did not buy a gun to commit a crime. That's what it says. It's exculpatory, I understand, but it was not asked about, is what I'm saying. So it's not an inconsistent statement.
Read the entirety of what you think it says
Okay.
for me.
What was the number again?
Oh my gosh.
What was the page number right now?
Okay.
They're a mess at the end of this day. It just seems like they're not making motion.
It's closed now. You thought it's. I think you said that you thought it said, I told thugs, stop messing with everybody, like, don't buy no guns for no crime.
No,
Okay.
that's not what it says.
What does it say?
Find my page that I lost. Does anyone remember the page I?
Bless you.
Your Honor, it's when he says, according to the audio.
It's Mrs. Zachary. I have 149 again, and it's Detective Dennis saying, so they just get,
Look behind his foot. He's just got stuff on the floor. Like, what is going on, Steele?
excuse me, so they just got sticks on deck, meaning guns?
Right.
No, where are they getting them from? Thug got a check, so it's not, put a date on this and it's unintelligible. Then the next person says Thug, Mr. Zachary says Thug, and then Mr. Zachary said, I told Thug had to stop messing with everybody. He, like, buy no guns for no crime. That's what it is. Then the next line is out because it's about the illegal search of Mr. Williams' home.
All right. I mean, I think given my ruling, when Miss Love was doing the examination, and I told her to stop going line by line, that I'm going to permit that to come in. But with regard to the rest of your specifics that y'all, the variety of you raised right before the break, where Mr. Zachary acknowledged saying something, but then said it was a lie. That does not prevent that from still coming in as a prior inconsistent statement under 613. I mean, he's given an opportunity to explain or deny. He doesn't deny, he explains it by saying it's a lie. So the prior statement is still a prior inconsistent statement and can come in. So when we start with Detective Gaither in the morning, that'll be my ruling with regard to all of that, that it can all come in subject to the redactions that were already made under 613. Okay, so a couple of questions about, did we ever get the, Ms. Love, you were going to provide us with the specific parts of that? Mr. Zachary's Twitter that you wanted in?
So I do have some, but since I didn't push with getting them introduced with Mr. Sprinkel this time, I instead.
Right, but we still want to know what they are, so we'll know what needs to be dealt with.
Yes.
So can you tell us what they are?
Yes, so it was page 32 of 259. And what I'm going to do, Judge, is just scan them all. It's page 32 of 259. Page 63 of 259. Page 64, 66, 74.
Why couldn't she do this? Like
79, 81.
It's almost like she already did it,
86.
but chose not to send it through.
87, 92.
Other people's drama has entered the chat.
12, 15, 142.
Hang on, 12, 15, what does that mean?
That's the page number 12, page number 15. I had.
Oh, so we're going back. So before 32, page 12? I'm just confused.
Yes, it was.
Okay, so page 12.
Just begun.
All right, and then what?
Page 12, page 15, page 142, page 131, page 128, 129, 127, 126, 122, 119,
Paige.
117.
Paige is only putting up with this because she feels bad about yelling at Love earlier. So she's trying to give some grace, but it's just too ridiculous.
100.
The whole chat is on the Brown comparison here. I think there's a hearing. I could be off on when, but I think the hearing for the civil forfeiture is set for August. Brooklyn.
Is that it?
No, you're not doing that. It's just page 3. And like I said, I was scan these in order. Page 109.
August 18th.
175.
Yeah, thank you. I said, oh my God, I forgot about that.
Page 109. And like I said, I was scan these in order. Page 109. 175. Oh my God. 192. 198, 204, 220, 221, 240,
Trying to keep it together.
and Your Honor, at this time, that's what I have to present to the board. I asked the board to allow me to just scan any additional ones in it, one already chronological PDF.
A chronological would be wonderful. And then share that with everybody. And you now intend to introduce these the next time Mr. Sprinkel testifies?
Yes.
Which will be how long from now?
Probably not this week, given the, not,
After we get back from our?
yes,
Okay, after the non-jury days.
yes.
Okay. All right. Then that'll be yet another item for us to take up during our non-jury days. Okay, Mr. Steele, I have a question about your motion in limine number 61. In your paragraph 4, you raised the issue of text messages captured on the wiretap. Are there text messages captured on the wiretap?
There are line sheets. There are line sheets.
That write in proposed text messages, and I believe that would be hearsay.
Line sheets that write in what?
So line sheets that the agents create, and they're doing the minimization. And then on that, they have text message and they write what the text message is, but that would be hearsay.
Okay, I'm sorry, write that there is a text message or the substance of a text?
Substance, the actual substance of a
Okay.
text message. And under the case I cited,
Yeah, I mean, I looked at the case you cited and it doesn't seem to have a holding on much of what,
best evidence rule.
I couldn't quite tell the purpose for which you were citing that. So you're basically making a best evidence
That's true.
objection to these. Okay, I was trying
That's
to
true.
sort out what your objection was. Okay. All right, so that'll be something that the state will need to address. But you know what the objection is now. All right, with regard to the rest of it, I mean, I've already made a ruling that the text messages it was just the Verizon person anyway, that they are sufficiently authenticated that you can certainly argue to the jury. And it's ultimately up to them anyway, but it's a prima facie case for authentication and that's been made. And it is not accurate that it's already been proven that those text messages are not verbatim. What the witnesses testified to was that they may or may not be verbatim, not whether they are or not. That it's possible that something might not be verbatim there. But anyway, with regard to authentication, they have been authenticated, so I'm not going to exclude them, and that'll just be an argument that you all can make to the jury. Okay. And then we'll circle back on the best evidence with regard to the wiretap texts. Okay.
We get an Atkins argument. I see a long arm.
Your motion in limine 62 deals at this point with Mr. Kendrick's guilty plea potentially coming in and Mr. Ryan's conviction potentially coming in. And I don't know, we had discussed before that if that did happen, that there would at the very least need to be a very tight limiting instruction about that. And I don't know if it is the state's intention to introduce either of those things. And if they are arguing that they can come in against anybody other than Mr. Kendrick for his and Mr. Ryan for his, or what the argument is. So can you elucidate us on that so that I know what I need to be
Here we go, love.
thinking about?
Explain it, love.
Judge, I agree that there needs to be a tight instruction, and I just asked for the opportunity to submit a proposed instruction.
All right, but you agree that it's a confrontation clause issue with regard to it coming in against anybody other than the person who was convicted of it, right?
With respect to the plea, definitely, and with respect to the conviction, probably, and I'd like to look that up. I want to make sure, but definitely with respect to the plea, because that's a statement that he's making.
Okay, well, it's it's equally clear with regard to the jury conviction. So you can look it up if you want to, but it is a confrontation clause issue with regard to it coming in against anybody else. I don't know when that might happen, but
Not before we come back into.
okay. I'm still trying to make a determination. Okay, so I guess that's the only argument right now, is that it's a confrontation clause issue, and yes, it is. So at most, it could come in against those specific people with a tight instruction, and I'll see if anybody else raises anything else.
Okay, and I tried to craft an instruction, and I can't do it because I don't believe that it passes intellectually to expect anybody, a lawyer, to really hone in and say, okay, I'll just use this against Mr. and I'm not picking on, but Mr. Kendrick for this purpose. And yes, I could use all the evidence against everybody in count one, but not that one piece of evidence, but I'm going to use it against Mr. Kendrick. And by the way, in that indictment, it says the gang YSL, but I'm certainly not going to use that as an admission against anyone else. So I gave up on an instruction.
All right. So, I mean, yeah, there's definitely a potential danger there. So if we don't come up with a good enough instruction, then that stuff can't come in. So it's incumbent upon the state to present something that's workable.
Yes, Your Honor.
All right. And then on the motion limiting number 63, I'm not going to go through the specifics of that one right now. It's pretty detailed. But that's another thing we're going to have to go through. Now, in terms of, and I don't even know if Ms. Good is going to testify or not, but I guess you're not limiting it to Ms. Good. You're saying these portions shouldn't be used with any witness, right?
That's true, unless it's better than, I heard from my cousin who heard from this person. That's how it comes out.
Okay. So now you actually say from asking questions and playing for impeachment, which that's one thing, or to refresh memory. And I mean, if you're refreshing memory, you're just presenting it and they're supposed to be looking at it silently. And I think something doesn't need to be evidentially admissible to be something that could refresh somebody's memory. So
I was once trying a federal case and the witness couldn't remember, and the prosecutor, U.S. attorney, wrote down a piece of paper in his pen to refresh the memory, and I objected. And the judge sustained it, but said, actually, it does say you can refresh memory with anything, but the judge did still sustain it. But my point is, yes, I understand, but it's inadmissible anyway. So I was focusing on some are good. And why would we refresh memory on something that's not admissible? So
because it might refresh their memory
about something that's not admissible.
So, I mean, they may not then be able to testify about it, but I'm not going to limit them in what they can use to refresh somebody's memory.
All right.
The rest of it we'll take up later.
Except for a lawyer writing it out on a piece of paper.
If that happens, we'll take it up at the time, but I suspect my ruling would be the same as that judge's. Okay. I just want to inquire, because it's been quite a long time since I did more than suggest.
The witness
ordered
list?
The state and counsel for Mr. Ryan to get together on what they could stipulate to and what they agreed, maybe not stipulate to, but what they agreed was in and out with regard to all sorts of different evidence. Have y'all done that yet? Okay, great. So y'all be able to present that when we get together early next week. I'm trying to think what else we need to think about or could discuss or could get out of the way right now.
Have that hearsay, double hearsay matter.
Are we ready on that? I mean, it's been a while too that we were going to take that. We had kind of gotten stopped on one of the wiretap
nested hearsay
things.
is coming up. We can watch that in our next get together, where Bruce goes off about nested hearsay.
Maybe we won't get bogged down in that right now. So I had asked a while ago and maybe I got some of it, but on the unindicted because they were subsequent to the indictment and allegedly intrinsic acts.
That took place after 2022.
I had asked, and I know y'all wrote briefs, but did anybody come up with, and Mrs. Bossy said she couldn't find anything, but has the state been able to come up with any case law where that's kind of factually in alignment?
So not on all fours, but I did find cases in terms of the way it's just outlined here, but I did find cases that spoke to the admissibility of overt acts that occurred after and the admissibility of overt acts that were not included on the indictment. But
That was what was in your brief, though?
I
Or-
think additional ones to
Okay.
those in the brief.
Do you mind just maybe sticking those in an email with the sites and sharing those with everybody?
No, I do not mind.
Okay, that would be wonderful.
All right, I think they wind this out.
Your Honor, I just wanted to put a couple things on your radar. I also filed a motion similar to Mr. Steele's regarding witness good. Just so,
Okay, I
that
did
was,
not see that one.
that was filed today. I just emailed it to Ms. Persifield.
Okay.
It's been accepted today, but the other thing I was wondering if the state could just tell us where, I assume at some point in the near future, we're going to discuss these Twitter records from Mr. Zachary or whatever they are. I think they're
Right.
Twitter. Could you just tell us where in the discovery they are?
Yeah, yeah, she was going to resend the link. What's easier?
I sent it to people internally and they had problems opening it, so I.
Okay, do you know which discovery tranche it was shared in?
No, not the discovery tranche, just a link for them, but I know that, I'll do a search in Dropbox for it.
Were they served in discovery?
Everything else in this file, everything else in the file that it came from, including attorneys.
I don't think they can hear you. Pull the mic to you.
I believe that they were, considering the fact that the entire file that they came from was served, inclusive of notes, internal emails and the like.
Okay.
Wind it down, Paige.
All right.
So again, you guys, this was September 30th, day 138.
Okay, so
And then they cut us down here. Oh, did I freeze? I think I froze.
yeah,
Jeanette.
if everybody can just do the things that we all just talked about. I'll see everybody at 8:45.
Okay, I think we're back.
Thank you, Your Honor.
Thank you.
That was weird.
Yes.
There was one matter that I believe the court had said that we were going to revisit.
What was
No?
Look it
I
up,
don't-
kids.
Your Honor, I just wanted to briefly, when one of the upcoming witnesses is Agent Bernie, who did the cell site tower analysis.
Okay.
And so I think this was back in August. One of the events was the shooting of the tour bus on April
Uh-huh.
of 2015 of Mr. Carter. And so I told the court and defense counsel to give them time to digest that analysis because it happened after that act's testimony. So the state would prefer to, because it's the same calendar year, it's 2015, to walk through those slides with Agent Bernie when he testifies. But I
Mhm.
wanted to, make sure that with the court's prior discussion now almost 2 months ago, before asking any questions about that. And so I wanted to just raise that now.
Okay.
Like, I love leaning away when Atkins is talking with his arms.
Any issue with, is it Detective Bernie?
Especially, Your Honor.
Agent Bernie, Special Agent Bernie, testifying to that incident as well, the phone records with regard to that incident? Y'all had him for a good bit of time now.
I have the phone records. I'm prepared for it, but it is cumulative. But I made this argument to you before, and I believe you said that, or the state said that Agent Hearsay was challenged as to his qualifications. That challenge was overruled, and he testified fully about it. We went on, and I don't remember how long, but day with the state putting down on a pad in front of the jury all these different calls and all these circles and diagrams that the state brought in. So I still maintain it's cumulative, but I asked you that before, and you said that you would allow him, my memory is you'd allow Agent Bernie to testify, but not to go through the whole thing again. That's how I remember it. If I'm wrong, please correct me, Your Honor, or anyone else, but I really don't want to sit here again and do the whole thing. And I don't mean that to be curt. It's just, it's inappropriate to keep redoing the same thing, because I didn't challenge anything about Agent Bernie for that shooting.
Okay, y'all understand the parameters?
Your Honor, I do understand the parameters,
All
and
right.
the state's intent is to with Agent Bernie, that slideshow that I'm referencing, that he conducted, that's going to be the extent the
armed.
state's not going to be rehashing ground that was covered with Detective Racy.
All right.
When you say the slideshow, Mr. Atkins?
The August 8th, that Dropbox link, it's in Special Agent Bernie's subfolder. No, and what I just sent, Your Honor, to be clear, there was a toll analysis that Agent Bernie did. So there's an Excel spreadsheet that was in that August 8th Special Agent Bernie. The state visually, there's some physical boards printed right behind that witness stand that we did with Detective Racy. It's the same data. Phone X called phone Y for 30 seconds at 7 o'clock. Phone Z called phone S, on and on. So the Excel spreadsheet, those same calls, the same data that Agent Bernie conducted is visually it's being printed on physical boards. So
Okay.
they're not physically built, but I sent the template that our graphics team is putting that information on. So it's the same information. It's just going to visually look a little different than just an Excel spreadsheet.
Okay. All right. So tomorrow we'll have Detective Gaither and then who? Okay. So those will be ready by tomorrow then?
That is, yes, Your
They either
Honor.
will or they won't be.
Correct, Your Honor, correct.
Okay. And then is that going to carry us through the day, those two witnesses?
Yes.
Okay.
So there we go. There was that. And guys, so to follow up on those issues, I'm a little lazy here. I didn't pull up the actual motion. I'm just pulling up this little screenshot because it's short. But if we zoom forward, this is October 8th, 2024. We end up having Adrienne Love file this motion to revisit this evidentiary ruling that she already asked Whitaker to reconsider more than once on the day that we just watched. She says, we move this honorable court to revisit the court's ruling, excluding State's Exhibit 528Y, attached here too as Exhibit A, on the basis that the exhibit contained inadmissible hearsay. Now, that exhibit was this exhibit with the phone number and the comments that were supposed to be redacted. So after all of that whole day is centered around trying to get in stuff that she wants to get in, but for one reason or another can't. She's denied, then messes it up when she could have gotten it in appropriately. Has to sit down, is admonished and yelled at by Whitaker, and then a week and a half later, would you reconsider that? So there was that, and this same time period, on October 11th, we're going to rely on a Thugger Daily clip just to get the clip in real quick. It might not seem like it's about love right away, but
with this court. That's all to us, the ex parte communication.
We start off, Doug has something he wants to bring to the attention of the court and make a request.
To us, the ex parte communications you received from Madam DA Fani Willis. Given the sensitivity and the history in this case of ex parte meetings or maybe communications, would you just please request the state? I understand probably what was behind that communications. And of course, it is great for a boss to buck up an underling who has perhaps been attacked or maligned. But I don't believe that, and I don't think the court does either, that the court should have been copied on that communications, especially one that reads maybe more like a campaign ad with a surf story in it than anyway, I just don't believe it was appropriate. And I would just ask you to please ask the state to halt any future communications ex parte they might want to have with this court. That's all I have to say. Thank you, Your Honor.
Yeah, it's a shame that the court would even have to say something like that. But can you all please communicate to everybody in the DA's office to not have any sort of ex parte communications with the court? And y'all may not even know what I'm talking about because I don't think either of you was copied on that email, but Ms. Love was. Ms. Hilton, you were as well?
I do, Your Honor, and I don't know, I know exactly what you're talking about. I think we have a different perception of direct communication with the court, but we will make sure that.
But the court was copied on it. And it could have been an accident, but
Hilton.
Your Honor,
it should have been careful
But the state did not have the initial conversation with the court. That was
No, I
a
know that.
community member, and it was very much a reply. Also, was not a direct communication with the court, but we understand the court's perspective. We understand what the court is saying.
Oh, excuse me. I just need to take issue with the fact that it wasn't a direct communication from the court. I'm sorry.
Excuse me, can you hear me now? I didn't mean to act like Matt Sharp. I take issue with any type of suggestion that this was not a direct communication with the court. It went from Madam DA Fani Willis to this court. It was a direct communication to this court. It was inappropriate. It was praising Georgia's RICO statutes to the court, which again was not appropriate, Your Honor.
He's like, what did I just walk
Frankly, I think it might be a good idea to print out the email and make it a court's exhibit to this record. But I think what Ms. Hilton was just saying was that the original communication was not from the district attorney's office. The original communication was, I don't know who this person is or where in the world they are, but some member of the world, member of the public, emailing Ms. Love directly, but copying several other people, the court included, because of course our email addresses are a matter of public record. And, you know, I basically ignored it and deleted it. But as you all know, because I forwarded the next communication to everybody, the elected DA, Ms. Willis, made a decision to respond and directed that response to Ms. Love, but kept everybody, including the person who had made the original email communication, and the court on her response to Ms. Love. And I believe that to be ex parte, and that is the reason why as soon as I read it, I had Ms. Persifield forward it to all counsel, because I don't think that should be going on.
And I certainly appreciated that, Your Honor.
And the court really has ignored entirely the substance of the communication, because the court is not making any decisions based on whether I think the RICO statute is good or bad. That's not what judges do. The legislature enacts statutes. I apply them hopefully correctly.
So shout out to the Honorable Thugger Daily for
to
having
us.
this clip around the same time. Again, going back to everything that we watched at the beginning of this stream from that day with the yellow blazer, we have this issue of Sprinkel being on the laptop addressed.
When I read that, go ahead and sit down. You're sworn. You're already.
He's already in the room.
Yes, Your Honor.
Okay, so you're still under oath, and I'm going to recall your attention to, I think it was the last day of your testimony, but it was there was a laptop on the.
And notice, Love's desk is empty. There's nothing here but an expo marker and a tissue box.
Witness stand, and you accessed it.
Yes.
And you actually did that without anybody asking you to, or asking the court's permission. But can you tell me what all you looked at on the laptop?
Yeah, I had my supplement, that 140-page document, and I also had some of the stuff that I pulled during the case. Everything that's already been turned over in discovery, just in case I need to refresh my recollection. But primarily, it was just it was a digital version of the report that I had on the stand. That was it. So I could do word searches. So if I was asked a question, I wouldn't have to be flipping through pages and looking for things.
Okay. Was there any point in time when you accessed anything else other than that report and the files that were connected to that?
No.
Okay. Did you in any way read any communication that came in at any time from anybody?
No, I wasn't communicating with anybody. I didn't have email open or anything like that. All I was looking at was the report and the digital media, like the discs that I brought to the stand with me, that stuff that was on the discs and the stuff that was turned over in discovery. That was it.
All right. We may call you back at some point with regard to this, a motion that has just been filed after lunch. Are you going to be around this afternoon? And I don't know whether you'd be needed for that or not. Haven't read it in detail, nor do we have a response from the state yet. But would you be available this afternoon if we need you?
Well, I'm just one floor up, Your Honor, in courtroom 2B. I do have a couple of cases, but I mean, the short answer to your question is I will be
down
in the
here.
building
Okay.
and the moment I can
Okay,
peel
and I don't
away.
know, like I said, whether you'll be needed or not, but all right, thank you.
Okay.
Again, like that day, the mess of that day with the yellow blazer just did not end when the day was over.
Gonna do this.
And of course, we're gonna replay the yak reaction to Doug real quick. Crowd request in the chat. Actually, I think it was before this. Yeah, it's over here. Here we go. So let's look at Yak's face when he reacts to the zinger from Doug.
Take issue with the fact that it wasn't a direct communication from the court. I'm sorry. Excuse me. Can you hear me now? I didn't mean to act like Max Short. I take issue with any type of suggestion that this was not a direct communication with the court. It went from Madam DA Fani Willis to this court. It was a direct communication to this court. It was
and he puts a serious face back on. And now, well, okay, I have an interjection. So, YP Kamshik, good to see you. I saw there's 2 results for Michael Sprinkel on the website, the Fulton County website still, and they both seem to be the same, and they're both under the case intake division, but one, the text looks the same, the other has a picture. So, and it's still under the case intake division, so I don't know if he has 2 profiles or maybe they created a profile without his picture to get him off of a directory listing. Maybe there's some logic built in if they use like WordPress or something where display all cards in case intake division if picture is present, and they created a profile for him without one to remove it. I don't know, but he is still on the website. He is still on the website in some way or form. And where was it? The last thing we've got, we're going to round it out. Noticing that Love's seat at the table is empty a week later, but we have this wonderful ex parte forwarding email about Adrian Love and the RICO statute to everybody. We're going to round this out by reading that. So we have, this is the subject, YSL RICO case. What are you doing? Miss Love, please ignore this foolishness. As you know, the elected district attorney is extremely proud of you. Let's actually clarify that this is Fani writing this herself. So as you know, the elected district attorney, me, myself, is extremely proud of you and believes you to be a huge asset to this office, comma, and our community. You have no chance of losing your job, and your service is greatly appreciated. Folks who have never tried cases will always have nasty things to say, but while they criticize from the sidelines, they fear the arena. They are not risking life and limb to keep our community safe. Let me tell you an anecdote of encouragement this morning. A good friend of mine called this weekend and said she was in an Uber, and the Uber drive randomly began talking about being from Memphis and how much violence there was in Memphis. She said the Uber driver said in Memphis, they do not have the ability to do RICO. He said, I am so proud of our DA here in Atlanta and her YSL team. They are not afraid, and they are fighting for justice. She's still talking about herself in the third person. I tell you this random anecdote to encourage you to brush your shoulders off and keep your eye on the prize. The watch, the hundreds of thousands of dollars in cash, the conviction so we can apply for more grant money and get more money from the state than other counties, more from the Fulton County Board of Commissioners, accolades, press conferences, the prize is justice, apparently. Please know that your boss gets 100 nasty messages, from Nathan Wade, and 100 nice messages a day. I focus on one thing every day, representing my community in a way that is fair. I'm asking of you to continue to focus on justice and ignore the haters. I'm extremely proud of you. Now go make it an amazing day. Yours in service, Fani T. Willis.
It was an amazing time.
Are you certain?
Why is this so giant? Why is this so huge? If you're going to write your name this big in this message, you don't need to refer to yourself in the third person with your title through the rest of the message. There's no reason to do this juxtaposition. Like, what are we doing? Oh my goodness. This whole letter. Yes, the random anecdote. Curious Leigh says she writes like she has to meet a word count. Yeah, Cindy Len says, remember when the judge had to order all of the DA's office to take a course in Brady? Ex parte, Brady, they got away with so much. Yeah, can't forget the Lambo. Jeevy's like, no, do we have to read it? Not quoting Jay-Z lyrics. That guy Nick very humbly says, I'm no stranger to being cringe myself. I've been there, I feel you. But this may be one of the top 5 cringe things I've ever seen. I would never do something like this. Blocking out the haters. Now, Fani, go sit your ash down. Hey, you had a missed opportunity to go sit your Fani down. Just crazy. Just crazy. Yeah, Uber driver from Memphis randomly following this case and having good things to say about it. Does Vera drive Uber? Who is this? Just crazy. Yeah, and this is definitely one of the best memory lanes, especially since it pertains to love. We couldn't do a Love-a-Palooza without highlighting that. And this was the perfect day. Again, Factual Lie was like, can I do that day with the phone number when Whitaker like flips out at love? So here we are. Rounding it out with the perfect. She disappears. We get love motioning to reconsider that exclusion of that exhibit with the phone number in the comments. And then we get this praising fan club letter from Fani Willis, from the district attorney. Don't want to refer to her in the first person there. I remember this. I like remember this happening, but I don't remember it. So maybe we have to loop that back in. We might have to do a like Kayla Bumpus segment in this YSL reunion. We can work that in there. Oh, yes, Aaron. The elected district attorney. Let me get all of the characterizations in there. Chooses her fonts like she has to meet a page count. I still think Adrienne loves email signature. Because she has the giant cursive signature image when Love signs off on an email, but then she includes a proverb and it's like ginormous. So all of that. I do have a clip pulled up. I think it might be worth watching. You know, we had some requests for Woody, and I get that Woody has great moments, but unfortunately, or fortunately, I don't know, Love isn't the prosecutor that leads the questioning of Woody when he's on the stand. So maybe we could revisit the ex parte stuff. But that wasn't her moment to shine. That was really Hilton. That was Hilton's moment to shine. Or be outshined. But we do have Quindarius Zachary and multiple days. I think like 3 days of direct examination by Love that we could go back and watch. If you want a little sample to help you decide if you want to do that or not. Here's a little clip I think you guys will remember.
That chopper was brown?
My gun, how can I said guns that I know was on the scene that I used?
How many guns can you shoot at one time? You personally?
2, 3, 2.
At one time?
2.
How do you hold a chopper? How do you hold a 7.62 and a 7.23 and shoot them both at the same time?
Easy.
How?
Easy.
Show the jury.
I ain't showing no jury that, man.
Your Honor, would the court please instruct the witness to show the jury?
You're saying you can do it, so show the jury how it would be
Your
done.
Honor. I don't know how to do it.
Lying on the stand.
Do you recall telling the police that Tay had a 7?
Now, when has Love ever moved on so quickly from a question she wants an answer to? He's just sitting up there like, I don't know what he's actually doing. Gesticulating his hands to bide time. He's just up there like, doo-doo-doo, talking casually, and Love is trying to be so serious here. Oh, this is a time. This is a time. And wait, is there more?
6'2"?
Because I knew that I'm the only one had a 7.62. I knew that they know I had a 7.62 in my name.
Did your gun look like a big old deer gun?
Bleeding as hell. Was he hostile at this point?
Did you tell the police that Tay's gun looked like a big old deer gun? What kind of gun did Demekion have? Do you remember what you told the police about the gun Demekion had?
I don't remember.
Why don't you remember?
I don't remember.
Now, you were trying to protect Moncton, but did you tell the police that Demekion had Moncton's gun?
I don't know.
How would telling the police that Demekion had Moncton's gun protect Moncton?
I don't know.
Was the gun Demekion had the same gun that you got caught with in May?
I don't remember.
Did you tell the police that the gun you got caught with in May belonged to Moncton?
No.
Did you tell the police that on April 28, 2015, Demekion had that gun?
I don't remember.
Okay. How many guns had you bought by that time, by August 5th, 2015, from any kind of pawn shop?
I don't remember.
Had you bought any from Arrowhead Pawn Shop?
I don't remember.
Do you remember the police asking you about buying 3 or 4 firearms?
Objection 403.
Sustained.
This is why, so GV had found that the 403 objection day was from this particular day. And I was like, guys, that's it will take hours to rewatch this day and get through the 403 battle. But I should note that the same day that she filed the motion requesting for reconsideration on this exhibit, she also filed this motion annoyed with the 403 objections. So again, October, way later, she's taking issue with what's happening on days 135 and days 138. So here, Adrian Love hereby moves this honorable court to allow the state to present all relevant evidence to the jury and to deny objections to the presentation of relevant evidence on the basis that said evidence is a waste of time. Now, this is a short motion. I shouldn't be able to critique it, but guess what? We've got, first of all, we have a headline that's as long as the motion. We just leave out the state of Georgia. We don't even say comes now, but this is essentially the same. Secondarily, what she's asking for is don't let a 403 objection stand if we're assuming that it's relevant. You should not exclude something as being a waste of time. Rule 403 covers multiple bases, including relevance, balancing act, waste of time, could be cumulative, could be confusing to the jury. She can't just assert, she can't make the assertion that everything we present is relevant. So please stop sustaining objections as to waste of time. They're two separate issues. So you should be arguing, don't sustain something as being a waste of time. Here's why it's not a waste of time. But instead, we have Adrian Love just mad that she's getting stuff sustained and she's still griping about it a week after it's actually happening. She's just going to spitball this out. And we're going to revisit that motion in limine where she asked Glanville to stop sustaining leading question objections. and gives a leading question example in that motion to exemplify why her leading questions aren't leading questions. Just a great use of motions in limine. But yeah, so I think even if we don't watch all of Quindarius Zachary's time on the stand where Love was doing the questioning, we will watch this day. He was on the stand for multiple days, and there's also all of the issues where she was arguing, I think horribly, with Dennis Scheib about his health status and his detainment status, and the immunity, because remember, they gave him immunity. But at the very least, we will spend some time rewatching this day. This was like, yeah, there's a long break there. There's long lunch break. But I think even cutting that out, it's probably about 6 hours worth of material. So this might have to be a day that I can start in the morning or on the weekend. But we will rewatch this day. And thank you, Jeevy, for finding this day. And Hal, did you want to hear this part a little bit to finish out this line of questioning? I don't know how much that would
Do
be.
you remember talking about buying 3 or 4 firearms?
Objection 403.
Sustained.
Judge okay. Did Woody trick you out of those guns?
No,
Did you tell the police that Woody tricked you out of those guns?
I don't know.
Did the police show you yourself in Arrowhead Pawn Shop buying those guns?
I don't know.
Did Traydon shoot any guns?
I don't know no Trey Dunn.
What now?
I don't know no Trey Dunn.
Did Tay shoot any guns?
One might have done with me.
What now?
He wasn't there.
Do you remember telling the police, nah, Traydon did not shoot any guns because he was driving?
I don't know.
Did only you and the driver stay in the car?
I got out and shot.
Did you tell the police that you and the driver stayed in the car?
I don't know.
Now, where did you all park when y'all got to the house on Adel Drive?
I don't know.
Did you tell the police that you and Moonton parked way back and Taynam got close to the house, like the front driveway or something? Do you recall whether they shot the house or whether they shot people?
I don't know.
Do you remember saying last week that you saw people running into the house and you had followed the car?
I don't know.
So we'll reserve this. We'll go through this whole day. We'll count again the 403 objections. I think that'll be a fun time. And remember, when we get to Doug getting up on the stand for cross-examination, Love tries to fire the 403 objections right back, which is hilarious because she's, oh no, don't allow 403 objections to be sustained a week later. So, oh my goodness. And then remember, he also, we've got a witness here with immunity. I believe, at least that we know of, we know Kenneth Copeland had immunity. We know, or some extent of immunity. I think use immunity also for Quindarius Zachary. And what is Polka's name? I don't remember Polka's name right now, but Polka, I believe, had some type of immunity relating to, the gun. Why wasn't it on your person? Why didn't you know where your gun was? Something to that effect, to protect her from being charged for that. Yes. Thank you, Aaron. Taisha Alexander. Thank you. So, but we're going to rewatch this. We're going to figure out what's going on with, apparently Love is asking about 2 guns. And granted, Quindarius Zachary isn't being cooperative here. And it sounds like he's not. Maybe if he's not being forthcoming, sometimes when he's being forthcoming, maybe there's credibility issues there. But the problem is Love is using this opportunity to allow her questioning to sort of act as testimony. And if she's inserting certain things in her questions, which she's kind of got a little leeway to do by being leading, because I'm pretty sure he's been declared a hostile witness at this point. But still, if she's trying to beat this point across the jury's heads that two guns were used in the shooting at 428 Adele, which also took place on April 28th. Yeah, it seems real slick. So, but yeah. Yeah, and Polka is the girl that was in the viral video. Like, and more power to her for that. You know, to me, it looks like those girls are running up on her and she defended herself. So I think the immunity wasn't related to that. I think the immunity would have been related to, you know, having someone else maybe possibly have your gun, depending on how her testimony went and how Fulton County would have wanted to use that against somebody, should they want to. So, and then GV, yes, oh my gosh, we have to redo that. GV says, remember when the state wanted to enter Quindarius Zachary's dad's phone call into evidence? That was insane. And Paige almost passed out from secondhand embarrassment. That was like yelling for like 7 minutes straight. Oh my gosh. Yep, so factual lie, we're going to actually wind this down. Factual lie stayed up late. Thank you so much, Factual Lie, for the suggestion on this particular day. I think it was a good subject to put together with that Uber Germany letter and the October motions. Tomorrow might be shorter clips if we get together in the evening. If I can get work done tonight, I might be able to stream longer starting early, as if we were in court all over again, early in the morning, 8 or 9. But if I can't make that happen, we'll watch some shorter clips and highlights tomorrow. Maybe the nested hearsay argument or whatever. But we will get to this day when we can do like 4 or 5 hours. With that being said, thank you guys for doing this YSL reunion. Also, big thank you here earlier in the chat. Nika had said, oh, how I've missed the YSL crew and has been here for 9 months. So big thank you there. And whatever happens, don't go out there telling people you can fire 2 or 3 guns at a time, because Adrian Love is going to find you and ask you to be an expert witness in a trial eventually. So take care until next time. Have a good morning, evening, or good night. Bye, guys.